Good morning, I'm Ed Lingao. It is Monday, the 17th of March, bringing you Morning Matters because your mornings matter. The camp of former President Rodrigo Duterte is now preparing for the confirmation of charges, which is set to take place on September 23. And expected to join his counsel is British-Israeli lawyer Nicholas Kaufman, along with former Executive Secretary Salvador Mijaldea, former presidential spokesman Harry Roque, and VP Sara Duterte. Let's get more details from Gretchen Ho, who joins us live from the Netherlands. Gretchen, guten Morgen. I don't know if that's how you pronounce it. Good morning to you.
Guten Morgen. Good morning to you from here at The Hague in Netherlands. A good Monday morning to everybody watching over at the Philippines. The defense team, as you mentioned, is taking shape for former President Rodrigo Duterte for his defense in the International Criminal Court, and leading that is Attorney Nicholas Kaufman, a seasoned international lawyer whom the Vice President met over the weekend. And also part of that team is Attorney Harry Roque, who has been missing from Philippine shores, possibly being part as a support lawyer. Here's my report.
Ako po, ang pangako ko, hindi ako aalis ng Netherlands na hindi kasama si Presidente.
Those were the words of Attorney Harry Roque in a protest rally at The Hague in Netherlands, with supporters of former President Rodrigo Duterte from different parts of Europe in attendance. Roque, who has been missing for months, surprised many when he suddenly resurfaced at The Hague.
Aampunin niyo ba ako? Ang hindi alam na mga bangag dito sa Europe, baliwala ang kapangyarihan mo. Dito sa dahig, ito ang sentro ng karapatang pantao. Net-net mo, hindi mo ko makukuha dito.
The former presidential spokesperson, now a fugitive according to the House of Representatives, faces an arrest warrant issued in September 2024 for contempt after failing to submit financial documents linking him to Pogos. Roque, who once celebrated the Philippines joining the ICC in 2011, is now questioning the jurisdiction of the court.
Bakit kinakailangang mga dayuhan ang maghusga sa isang Pilipino sa krimen na nangyari sa Pilipinas? Ang sabi nga ni Presidente nung siya'y hinuhuli, mas ninanais kong mamatay kesa husgahan ng mga dayuhan.
And he will get to do so formally if he is approved as legal counsel to former President Rodrigo Duterte, who is now a suspect before the ICC for crimes against humanity of murder, torture, and rape. According to Vice President Sara Duterte, they've gotten the services of British-Israeli barrister Attorney Nicholas Kaufman to lead their defense. Attorney Kaufman, a veteran international lawyer, has handled high-profile cases, including former Congo Vice President Jean-Pierre Bemba and Central African Republic Minister Maxime Mokom, both charged with crimes against humanity in the ICC. Bemba was in prison for 10 years, 8 years awaiting trial and verdict, and 2 years upon his conviction. His conviction was overturned when a judge decided that he could not be held responsible for the actions of his men. Kaufman is a trial lawyer who specializes in litigation, crisis public relations, and reputation management. Joining Kaufman in Duterte's defense team is former Executive Secretary Salvador Mijaldea, who had already been recognized as his legal counsel. Attorney Harry Roque, who is an ICC list counsel, known for his work on human rights and international law. And Vice President Sara Duterte, who has declared her intention to stay with her father's legal team as long as there is no other family to replace her at The Hague. On the other side of the fence is British-Pakistani Karim Khan, appointed chief prosecutor of the ICC in 2021 for a 9-year term. He has led probes into the Taliban and Islamic State in Afghanistan, Russian President Putin for alleged crimes in Ukraine, and Hamas and Israeli officials over the Gaza conflict. The confirmation of charges hearing is set to take place in September 23, 2025, and the defense has hinted questioning the jurisdiction of the ICC as well as the mode of arrest.
And in the confirmation of charges, they will establish that there really is probable cause and that there really is jurisdiction. I will also bring the issue of the illegality of the arrest of the former president.
Yes.
That should lead to the court losing its jurisdiction. And I would be citing case law from the Constitutional Court of South Africa that an illegal arrest is sufficient to divest the court of jurisdiction because you cannot right a wrong by the commission of another wrong.
And we got to talk to Attorney Harry Roque and ask him how long he plans to stay here at The Hague. And he said it will be indefinite. As long as this is happening, he will be here. And definitely one of the strong voices leading gatherings here in Netherlands. So that's not the last of it. There will also be a meet and greet with the Vice President this coming March 23. And we're expecting something big happening at March 28, the birthday of the former president. That will be celebrated here in the Netherlands. But apart from that, later tonight, there will be a prayer vigil for victims of extrajudicial killings that will be happening in front of the ICC headquarters. So a show of force all over here at The Hague, Netherlands. Ed?
Well, of course, Gretchen, Harry Roque is being sought here in the Philippines, specifically by the Senate. I'm wondering if that in any way will affect his chances of being approved as part of the legal team in the Netherlands for former President Duterte.
Actually, tinatanong nga natin kung kasama ba siya doon sa legal team na yon. Hindi pa tayo mabigyan ni Attorney Harry Roque ng definite answer. Lagi niyang nababanggit na may team na nag-handle kaya hindi na siya makapagsagot. That's why when we ask about the next steps when it comes to the case, will they, for example, challenge jurisdiction before the confirmation of charges hearing on September 23? Sabi niya, hindi siya makapag-comment kasi meron ng team na nag-handle. So I guess he is also giving way to the lead counsel to be the voice for that. But as to his formal appointment as part of the legal counsel for the former president, in this case, we haven't gotten confirmation yet, and we'll be waiting for that this week.
Do we know when VP Sara Duterte is coming back to the Philippines?
Ang sabi niya, Ed, ay hindi siya uuwi sa Pilipinas hanggang sa may pumalit sa kanya na next of kin. Siya lang daw kasi yung may Schengen visa sa ngayon. Siya rin ang lawyer, so binubuo niya itong legal team ng kanyang tatay. Pero pinauuwi na nga siya ni Pangulong Duterte, ni former President Duterte, dahil nga ayaw nga ipaiwan sa kanya yung Pilipinas, but she has insisted that she will not leave without a family member around.
Mm-hmm. One more question for me. I'm not sure if you have the answer for this, but let me try anyway. The lead counsel of the Duterte group, Mr. Kaufman, Attorney Kaufman, well, it does seem like he has a lot of experience in handling crimes against humanity before the ICC. In fact, from how it looks like he's the only one in the team with any experience in handling cases like these. I'm wondering if his experience was with the defense or the prosecution in the two cases that you cited of him handling former African state leaders in issues of crimes against humanity.
Dito kay Vice President Bemba, ang interesting doon, defense siya noon, ano? Tapos ito si Bemba, kinulong siya ng mga 10 years. 8 years siya nag-aantay for the trial and for the verdict. And when he was convicted after 8 years, he served his conviction for 2 years bago siya nagkaroon ng reversal of the conviction. The judge ruled in the appeals portion that he could not be held responsible for the actions of his own men. So very, very interesting case. Actually, I think it merits a deeper look into that. There were also arguments on having a fair trial, on having enough evidence. So I guess when Attorney Harry Roque spoke about jurisdiction and about questioning the mode of arrest, there is merit to that in trying to say that the ICC has no jurisdiction because this is the mode of arrest that was done. Meron siyang tinitignan daw na South African case na gagawin niyang similar dito kung siya ay mabibigyan ng pagkakataon to build that case. Pero yung kay Bemba, yun nga parang alam ko hindi siya yung masisisi doon, and in his country, parang they found that he had limited power to investigate and to hold those guilty accountable. So may ganun eh. That could be relatable to the case of President Duterte.
You mean Attorney Kaufman was able to secure a reversal of the conviction of Bemba?
That's right. I was taking a look at what year he was part of the defense. Parang nung una consultant lang siya, and then from 2013 onwards, he was already part of the council. So meron din parang issues dun eh. So kailangan tignan. Pero ang nakita ko doon sa latter part ay siya na yung defense counsel ni Vice President Pemba.
Although it's also interesting to point out that we're talking about somebody who was a vice president, is that correct, of the country, not necessarily the chief executive?
Yes, Vice President of the Central African Republic, as I recall.
Okay. Maraming salamat. Reporting live from the Netherlands, from Den Haag, Gretchen Ho. The PNP says it is ready to aid the Interpol in apprehending any people involved in the drug war should warrants be issued. PNP spokesman Police Brigadier General Jean Fajardo says they now have a template for apprehending other potential suspects. This comes following the arrest of former President Duterte. However, Fajardo says they have yet to receive any information about a subsequent warrant from Interpol or the International Criminal Court. Retired ICC Judge Raul Pangalangan rejects assertions from former President Rodrigo Duterte's camp that his arrest was illegal. Pangalangan emphasizes that under international criminal law, Duterte's arrest is legally justified. He also notes that the ICC does not permit trial in absentia requiring Duterte's attendance in court. Furthermore, the retired ICC judge asserts that bringing an accused individual before the ICC, even through arrest, is a lawful and necessary step to uphold justice. Davao City Mayor Baste Duterte criticizes President Bongbong Marcos after his father was sent to The Hague. In his speech during the 88th Araw ng Davao, Baste said that they will fight back following the alleged illegal arrest of former President Duterte. The mayor says Marcos, and we quote, will never be loved and that he is nothing. Baste also, Baste also criticized the entire Marcos family, equating the president's family name with martial law and oppression.
Mr. President Marcos, you will never be loved. Especially to us who are calling out Roque Duterte's name, you will never be loved, Mr. Marcos. We will stand up and we will fight back.
Supporters of former President Duterte gathered at Taliwasang Bonifacio in Manila for a prayer rally. Wearing green and white shirts and carrying Philippine flags, the attendees demanded Duterte's release following his arrest by the International Criminal Court. In his speech, Senator Bato de la Rosa criticized President Bongbong Marcos for allowing Duterte to be sent to The Hague. De la Rosa also accused the administration of prioritizing foreign interests over Filipinos and claimed that the move was politically motivated to block VP Sara Duterte's 2028 presidential bid. The former president made his first appearance at the ICC on March 14 through video link. As we know, the Supreme Court has denied the immediate temporary restraining order on the arrest of former President Duterte. What's the next plan of their camp? And to answer that and more, we have on the line Attorney Israelito Torion. Sir, magandang hapon. I'm sorry, good morning. Good morning, Attorney Torion.
Hi. Good morning. Good morning,
Good morning, sir.
Kumusta
Thank you for
kayo?
joining us. Kumusta po kayo? I understand you've been really tired for the past few days.
Yes. Pero at least nakatulog na ako ngayon, medyo konti.
Okay, good to hear, sir. Sir, I understand that you filed a supplemental petition for motion for reconsideration with the Supreme Court after the Supreme Court earlier decided at least on the immediate issuance of FATIA-RO. Could you tell us more about that? What is in that supplemental petition that makes it different from the first one?
We actually filed a supplemental petition with motion for reconsideration where we argued why there is clear and mistakable right on the part of the petitioners to file that petition, and we cited the fact that President Rodrigo Duterte, if the person who is the subject of arrest warrant, so therefore he had the requisite legal personality to question that arrest warrant on the ground that it violated Article 59 of the Rome Statute in relation with Articles 8 and 9 of the Universal Declaration of Human Rights, Article 9 of the International Covenant on Civil and Political Rights, as well as the pertinent provision on the comprehensive model of law which implemented the Rome Statute. And in addition to that, since there is still a pending warrant of arrest, if indeed there is such, then Senator Ronald De La Rosa has the requisite legal personality to question the continued cooperation on the part of the government authorities, knowing that Philippines has already validly withdrawn from the operations of the Rome Statute, and therefore he had the requisite legal personality to question such continued involvement on the part of the government authorities. And we likewise argue therein that the case is still not moot and academic, on the ground that the Supreme Court can still order the respondents to make the proper representations with the ICC, questioning the illegal arrest made by invoking the leading case of the prosecutor versus Dragan Nikolic, where in that case also the ICTY had the occasion to rule that if there was grave violation of the human rights, if the accused was subjected to inhumane treatment and cruel treatment, then the jurisdiction of the court which issued the warrant is effectively ousted. We likewise argue that the claim that there was compliance with Section 17 of Republic Act 9581 has no basis, because the surrender, if you have to term it at that, has to follow either our extradition laws or which was not followed in this case pursuant to PD 1069, or it follows Article 89 of the Rome Statute, which likewise mandates that the national law of the accused has to be followed in cases of his arrest, which in this case Rule 39 Rule 39 Section 48 was not followed, and he was not granted his constitutional rights to question the validity of the arrest, or whether or not there was respect of his human rights when such was served against him.
Yes, sir. Sir, I'll zoom into the issue of whether or not it's moot and academic. I've seen some of the opinions being bandied around that it might be moot already. Because now, to begin with, the Philippine government has no authority or jurisdiction to ask the ICC or to order the ICC to return the former president. So what do you think of that, sir?
Insofar as that argument that the Philippine Supreme Court has no authority to order the ICC to release the FPRRD, that is valid, but the Supreme Court can order the government authorities who illegally, extraordinarily rendered President Rodrigo Duterte to the ICC. They can be required via preliminary mandatory injunction to make the proper representations or manifestations with the ICC as to why his rights under Article 59 was not followed, as to why UDHR, Universal Declaration of Human Rights, Articles 8 and 9 was not followed, knowing that we recognize Pacta Sunt Servanda, as to why Article 9 of ICCPR was not followed, as to why the comprehensive model law was not followed, as to why Rule 39, Section 38, Section 48 was not followed, that any foreign judgments have to be confirmed first before a regional trial court before it can be given effect here in our country. They can be required to do such manifestation before the ICC, and accordingly, there is also this question insofar as Senator Ronald De La Rosa is concerned, and therefore the case insofar as Senator Ronald De La Rosa is concerned, it is not yet mooted because the warrant of arrest has yet to be issued against him, and therefore there is still justiciable controversy insofar as Senator De La Rosa is concerned. And besides, there is this symbolic function on the part of the Supreme Court. In David versus Arroyo, the Supreme Court clearly said that when the matter is of transcendental importance, then it has the authority and the jurisdiction and the power to rule on such question. And if the case is capable of repetition, without the Supreme Court can rule on such issue. And even in Angara versus the Angara case, likewise squarely falls on this issue because it can guide future actions insofar as arrest warrants by a foreign court is implemented here in our country.
Sir, I can understand what you're saying about the case of Bato de la Rosa because that's for future reference. Kumbaga, if any ruling is made by the Supreme Court with regard to this, then that would definitely affect whatever happens to Senator Bato de la Rosa. But sir, what you were saying a while ago about the Supreme Court hopefully ordering the Philippine government to make representations with the
Yes.
ICC. But even then, that's only making representations. We cannot, I suppose.
Note, sir, in the prayer, I have 4 prayers in the petition. One of the prayers is the prohibition on the part of the government for continued cooperation with the ICC. Insofar as the Duterte case,
Yes,
then
sir.
the Supreme Court can tell the government authorities, hey, we already withdrew from the Rome Statute, so therefore you should not anymore provide evidences, you should not anymore provide any link whatsoever with the ICC, you should not anymore cooperate with further. So this is a matter which is still justiciable. And besides, in the number second that I prayed likewise, and third, there has to be a definite judicial declaration here in our country that we should no longer cooperate. Because under Article 127, Paragraph 2, the matter under consideration refers to judicial consideration. That there has to be pre-trial chamber order that orders such investigation. In this case, we withdrew from on March 17 of 2019, and the pre-trial chamber only ordered the investigation on September 21 of 2021. Whose fault is this? It's on the part of the Office of the Prosecutor because they allowed the matter to lapse after March 17 of 2019, where the effective date of our withdrawal took effect, and they only filed for a preliminary investigation, order of investigation on May 24 of 2021. So clearly, there is no more jurisdiction on the part of the ICC, and they cite Burundi case. I studied the Burundi case. This is a 2017 case. And the Burundi case was only allowed by the Supreme Court simply because of the fact that the pre-trial chamber ordered an order of investigation 3 days before the expiration of the 1-year period upon which Burundi is no longer part of the Rome Statute. So therefore, we have clear grounds that the Philippines is no longer under the jurisdiction of the ICC, and therefore it is still a justiciable controversy whether or not the Philippines should continue to cooperate with ICC processes, proceedings, and whatever actions that it may take concerning the Philippine situation, sir.
Yes, sir. Sir, you mentioned a while ago the use of RA 9851.
Yes.
And if I'm getting you correctly, I get the impression that you're saying that the word surrender can be taken to mean or should be taken to mean a form of extradition. Did I get you right, sir?
No, because ang problema lang kasi nitong ating mga ibang kaibigan, sinasite nila yung Section 17, hindi tinutuloy eh. Ang tingin ko kasi niyan, that is a form of an intellectual dishonesty. We should be clear to our people. Read the entire law. The, the surrender, if they like to term it as surrender, nandun eh, it should be pursuant to existing extradition and treaty. So any and all surrender to the jurisdiction of the ICC should be pursuant to existing extradition and treaty. So what is our extradition law? PD 1069. What does PD 1069 provide? It provides that the extradition request should be directed to the DFA. The DFA should refer the matter to the DOJ. The DOJ shall file an appropriate petition before the RTC. Now they will say, well, extradition will not apply simply because of the fact that ICC is not a state. Correct. It is not a state. So therefore, you follow Article 89 of the Rome Statute. What does the Article 89 of the Rome Statute provide? provide? It provides that such surrender shall follow the national law of the accused. So if it is the national law of the accused, then you should have the foreign order or judgment validated via confirmation proceedings by the RTC. That's Rule 39, Section 48. So therefore, what should have been done before it was served upon President Duterte, they should have filed the appropriate petition for confirmation of a foreign judgment or order before they served it upon President Duterte. But this was not done. I do not know why our experts keep on citing only a portion of the law without fully stating the law. What I am saying is there is here a grave violation of the human rights of President Rodrigo Duterte. There was inhumane treatment and cruel treatment. So therefore, the scenario contemplated in Prosecutor versus Dragan Nikolic would apply, and such inhumane treatment, grave violation of the human rights would or can be used before the ICC during the confirmation proceedings to move to oust the jurisdiction of the ICC.
Pero sir, what if it is not nga extradition because we're not talking about another state here, and what if secondarily, what if Article 59 of the Rome Statute no longer applies to us because we are not anymore part of
That's
the
baloney
ICC?
again. That's baloney. Why? Because if you read Article 59, paragraph 2, it speaks of the obligation of a custodial state. And what is the definition of a custodial state? In International ICRC-ICC Agreement Section 1. What is the definition of that ICRC-ICC Agreement Section 1? A custodial state is a state in which a person under a warrant of arrest issued by the ICC is detained while awaiting transfer to the seat of the ICC. A custodial state, therefore, is a country that has actual and physical custody over an arrested person pursuant to an ICC warrant, regardless of whether it is a state party or not. Okay? So, whether you are a state party, if you are the custodial state, then you have to bring him to the competent judicial authority. Kaya nga hindi ako nagpapa-interview before. Kasi nung in-answer ko yan, concerning a fellow dean of a law school likewise, that I cited that, nag-calibrate yung DOJ. Sila na daw yung, what you call this, competent judicial authority. Since when has the Department of Justice become a court? It has, in their own department circular, they say that they are performing an executive function. Now they are the court already. And besides, sir, Pacta sunt servanda states that treaties shall be complied with in good faith. We are a party to the Universal Declaration of Human Rights. Articles 8 and 9 mandates that a person arrested should be brought to the nearest competent judicial authority or to a court. Article 9 of ICCPR, of which we are likewise a party, likewise states that he should have his case should be brought to the nearest court. Our own Rule 113, Section 4 thereof, if you serve a warrant, it has to be reported to a judge. A judge here does not contemplate an ICC judge. It has to be a Philippine judge, which therefore reinforces my position that Rule 39, Section 48 should have been applied. There should have been a petition for judicial confirmation of that foreign judgment or order, but this was not followed in the case of President Duterte. Usually, kalma po ako, sir, pero kasi itong kaso na kasi ito na PRRD, kung dibatihan tayo.
Okay, I understand, sir. Pero sir, my last question, but in the end, sir, the Supreme
Yes.
Court found that your petition, at least your first petition, failed to establish a clear and unmistakable right for an immediate TRO. So in effect, Bale, you're also going against that he was still here,
That
you
is
tried
why
to get a TRO,
I
and
filed
then
a supplement to the petition.
Yes, sir.
Because ang nangyari kasi, sir, yung strategy namin, ako sana nun kay Senator Bato. Ang kakapal ng aming petisyon po, okay? Kagagaling ko sa Hong Kong, tumawag si Senator Bato sa akin the night before March 9. Bobet, may confirmation ako na meron ng warrant. Nag-usap kami ni Martin, okay, Delgra, by way of strategy. Ako kay Senator Bato, siya kay President Duterte na mag-file. nung pagka 9 and 10, na-instructionan ako, i-include mo na kasi prepara na yung kay Senator Bato, i-change
Yes, sir.
mo
Yes,
na
sir.
yung
Yes, sir.
first page and first page 5, ganon. So, I had to include President Rodrigo Duterte. If I will change some of the allegations, hindi na ako makafile ng kaso. So naiintindihan ko yung Supreme Court kasi we were racing against time. And in the 145 pages supplement to the petition, I clearly stated therein why there is clear and unmistakable right, because right in essay lang yan, tinuturo natin yan sa mga estudyante. How can there be no right of essay? Right in essay. Na siya yung dinadakip siya yung dinadakip. So, he had the right to question the manner of his arrest, not necessarily the legality of the warrant of arrest, even if he was not shown such warrant of arrest. He had the requisite legal personality po to question. Kaya nga doon sa sabi naman ng Supreme Court, the TRO is still open, no? It's still under the table, kaya it became a hint upon me to file a very strong supplement to the petition. Nasubrahan ko nga 145 pages yung itinula ko doon na nag-withdraw ako ng maraming English po kaya para lang ma-prove na meron talagang right in essay po dito.
Okay. Maraming salamat for joining us this morning, Attorney Israelito Torion, representing the camp of former President Duterte. And Bato de Rosa. Don't go away. We'll be right back with more stories after this break. Good morning, I'm Ed Lingao. This is Morning Matters. The ICC's charges against former President Duterte focus on only 43 specific killings out of thousands reported. And to provide insights, we are joined by Attorney Gilbert Andres, Deputy Executive Director of the Center for International Law, or Center Law. Sir, magandang umaga. Magandang gabi ata sa inyo dyan sa, I think you're still in Europe. Good morning, sir.
Good morning, Ed, and good, really very early morning here in the Netherlands.
Sir, let me start off with that. A lot of questions being raised by a lot of groups here in the Philippines as to why only 43 cases being cited, at least sa warrant of arrest. Some are saying na 43 lang, how could it be crimes against humanity? So can you walk us through what exactly happened here and why the number 43?
First and foremost, it's within the prosecutorial discretion of the Office of the Prosecutor as to which specific cases it will focus on. Secondly, actually, crimes against humanity, there's no really specific number. In fact, what's at issue in crimes against humanity is that there's a state policy or an organizational policy, and it resulted to a widespread or systematic attack. Now, what do we mean when we say organizational policy? That's a private organization, such as the DDS, of which Mr. Duterte was actually the head. And state policy, that refers to the term under which Mr. Duterte was the president of the Philippines. And according to the legal theory of the arrest warrant, because of the organizational policy of Mr. Duterte through the DDS and his state policy as president, there was actually a widespread or systematic attack. And the number is actually irrelevant. What's relevant is that it's all across the Philippines, and actually there were patterns to the murders under the EJ, under the war on drugs. So that's the widespread and the systematicity of it.
I brought it up kasi there are those who are saying that the math of the anti-Duterte group daw is faulty. Kasi how can 43 be equal to thousands or 30,000 being killed in the drug war? Also, some of them were saying na 43 lang pala. So all this brouhaha daw over 43 people being killed, and some were even comparing it to yung Maguindanao massacre where you had 58 people dying. So what you're saying is basically some people are looking at it the wrong way. We're looking at the sampling rather than looking at the exact number of people who were supposedly killed in the Duterte drug war.
Yes, Ed, kasi the Office of the Prosecutor cannot really present all of those 6,000 cases, deaths that were admitted to have occurred during police operations. The prosecutor cannot also present all of those 50,000 to 30,000 CSO numbers. That includes also the vigilante-style killings. Hence, the prosecutor, in accordance with his prosecutorial discretion, will choose the emblematic cases that will exemplify the widespread or systematic attack against the civilian population. And indeed, the prosecutor here has decided that these are the cases wherein there is evidence that can be supported that will lead to a trial and hopefully to a conviction.
Sir, I was talking to one of the lawyers of the Duterte camp, Attorney Israelito Torion. He filed last Friday. He filed a supplemental petition, or a supplement to their petition for the TRO, which was earlier denied by the Supreme Court. Now they're arguing na government, it is not yet moot and academic because government can still be ordered by the Supreme Court to make representations with the ICC for the release or return of the former president as well. The government can be stopped from rendering any further cooperation to the ICC as far as Duterte is concerned. Your thoughts about that, sir?
Well, number one, I think the Supreme Court will just have to refer to its previous rulings, especially the ruling in Senator Pangilinan versus Cayetano, which was a unanimous decision. In fact, it's also, I'm also a petitioner in that case, PCICC versus Executive Secretary. And the portion there is that the Supreme Court will actually not issue a mandamus or any extraordinary writ if it will cause embarrassment to the president as the chief architect of foreign policy. Because in fact, it's now a fact that Mr. Duterte is under ICC custody in the same way that when we filed our petition against the withdrawal with respect to the Rome Statute, the Supreme Court just actually cited the ICC saying that the Philippines was already withdrawn from the ICC. So I think the Supreme Court will just refer to its previous rulings wherein the Philippine president is chief architect of foreign policy. And number two, it will not issue any orders or judgment that cannot be enforced because in this case, it cannot already be enforced because Mr. Rodrigo Duterte is already outside of Philippine territory.
Sir, also still coming from Attorney Torion, he was saying that Section 17 of RA 9851 was not applicable in terms of the surrender of the former president to the ICC. Because it's either extradition daw or surrender. Extradition, in which case, should go to the rules of extradition under PD 1069, which means it would have to go through the local courts. And surrender daw, basically the same thing. It would also have to go through the local courts. Citing, I think, Article 59 of the Rome Statute. Your thoughts on that, sir?
Okay, first and foremost, actually, if you look at Section 17, it's surrender, may surrender, or extradite. Okay, I
Yes,
will just read the
surrender or
relevant
extradition.
portion, just to be
Yes, sir.
very clear. Instead, the authorities may surrender or extradite suspected or accused persons in the Philippines to the appropriate international court, if any, or to another state pursuant to the applicable extradition laws and treaties. Now, if we look at the word surrender, my legal position is that it actually refers to a suspect or accused with respect to the appropriate international court. Because remember, it's the ICC is not a state, so there's no extradition treaty between the Philippines and the ICC or with any other state for that matter, because it's actually an international court. Extradition process will only apply if the arrest warrant is issued by another sovereign state, because its arrest warrant, it's only operative within its territory and not in another territory of another sovereign state. Secondly, if you look at Article 59 of the Rome Statute, it actually uses the word surrender because that was actually very intentional. And if we look at travaux préparatoires of the Rome Statute, the delegates actually use surrender because they see this as not under the extradition regime of state to state. Okay, state to state transfer of a person who's being the subject of an arrest warrant. In fact, if you look at Article 102 of the Rome Statute, it says there, surrender means the delivering up of a person by a state to the court pursuant to the statute. And in fact, there's another definition there of extradite. Extradition means the delivering up of a person by one state to another as provided by treaty, convention, or national legislation. Therefore, if we look at Article 59, surrender is very intentional. It only means it does not actually put that person under the extradition regime. Thirdly, Ed, I just want to emphasize, if we are invoking that before the Philippine Supreme Court, which is a domestic court, we will actually invoke domestic law, correct? Mm-hmm. And actually, the operative fact is that we are not anymore a state party to the Rome Statute. Hence, in fact, Article 59 is not anymore applicable in our domestic sphere. And since it's not anymore applicable, we go back to Section 17 of RA 9851. So that's the applicable legal regime. And since it refers to the Philippine authorities, who is the chief architect of foreign policy who can surrender a person who's being investigated or prosecuted before an international tribunal? The answer is the President of the Republic of the Philippines.
Mm-hmm. Sir, my last question to you. Over the weekend, si Attorney Harry Roque, of course, representing the Duterte camp, he indicated that they will try to submit a manifestation questioning the jurisdiction of the ICC over the Duterte case, even before the September 23 resumption of hearing by the pre-trial chamber. So several questions there. Number one, is it possible for them to file a manifestation and have it acted on even before the September 23 date set by the pre-trial chamber? And number two, what are the chances here that we're looking at?
Well, it's essentially a challenge to the jurisdiction, and that will be under Article 19 of the Rome Statute. If that's the case, then the prosecution will also be given a period with which to reply to any jurisdictional challenge. And secondly, the court may, upon motion of the prosecution or the defense, may actually set a hearing for that. But in my opinion, I think the chances for a jurisdictional challenge to be successful is not so good. Why? Because actually the pretrial chamber was just look at the three issues of jurisdiction. Jurisdiction rationale temporis. Are the crimes here within the temporal jurisdiction, within the time period wherein the Philippines was a state party? And the resounding answer is yes. Because the crimes here are between November 1, 2011 until March 16, 2019. Secondly, the court will also look at whether the crimes occurred within the territory of the Philippines, or that's jurisdiction rationale loci. And yes, they occurred within the Philippines, in Davao and other places of the Philippines. Third is whether or not the crime involved is within the material jurisdiction rationale materiae. Yes, it's within Article 5 of the Rome Statute, which is crimes against humanity. So I think the issue really is the exercise of jurisdiction. But my position is that the appeals chamber also discuss exercise of jurisdiction. So there will be really, I think that's a hard stance to question the jurisdiction of the ICC at this point.
Okay, maraming salamat to you for joining us this morning, Attorney Gilbert Andres, Deputy Executive Director of Center Law. Thank you, sir, and ingat po.
Thank you. Mabuhay po tayong lahat.
Stay tuned. Morning Matters will be back after a short break. Welcome back. You're still watching Morning Matters here in One News. The arrest of former President Duterte has fueled a surge of false information on social media. One post claims that U.S. President Donald Trump signed an executive order for Duterte's release from the custody of the ICC. It also includes an alleged statement from Trump expressing sadness over Duterte's arrest and calling him a good friend. Another post alleges that $100 million was paid to the ICC to arrest Duterte. A photo collage has also surfaced online, falsely identifying ICC judges Yulia Motok and Socorro Flores Liliera as being with First Lady Liza Arneta Marcos. The people in the image are actually Katrina Ponce-Enrile and Katrina Roman Quintas. Additionally, a video of Police Major General Nicolas Torre III announcing his resignation is circulating out of context. The footage is from 2023 when he stepped down as QCPD director after a road rage controversy involving a former policeman and a cyclist. And then the Health Alliance for Democracy, or HED, has explained the inclusion of slain doctors in a protest rally in Manila. The group head admitted that Doctors Raul Winston Andutan and Dreyfus Perlas were not victims of extrajudicial killings during the drug war. They were murdered due to corruption-related issues, red tagging, and other reasons tied to the Duterte administration, the group says. The group apologized for any misunderstanding and said that they have already discussed the matter with the families of the doctors. However, Andutan's wife said they were not informed that they will use the photo of her late husband in the anti-Duterte rally. And to discuss these issues, we are joined by veteran journalist Vergel Santos of the Center for Media Freedom and Responsibility. He will also help us understand the impact of these false claims and how Filipinos can avoid being misled. Sir, magandang maga, and thank you for joining us this morning.
Magandang umaga naman,
Yes,
Ed.
sir. There
Thanks
you
for
go, sir. Yes, sir. Sir, full disclosure lang, sir. I'm also with the Board of Trustees of CMFR. Just as a full disclosure. But sir, I don't know if it's been coming up on your feed, pero ang daming naglalabasan na ngayon sa mga social media feeds ng mga tao with all these assertions and allegations, and a lot of them are turning out to be very colorful, very politically charged, but also very untrue. Have you also noticed that, sir, on your feed?
Alam mo, Ed, there's a vacuum to be filled. So people will compete on how to fill this vacuum. And not only vacuum, by the way, there are a lot of utterances going in the air that in which the public is bound to be lost. Kasi hindi naman nila naintindihan yan no? Hindi nila malalaan. They won't be able to tell whether they are simply being confused or being lied to or being told the truth. So I think news people have a very challenging role to play in this case.
Mm-hmm.
And it seems to me the only thing to do, useful to do for news people in order to make the public have a good understanding of the whole affair is for them to stick to the facts. And in fact, there are enough facts out there to be collected in order to make the people understand what's happening here. But then, sabi ko nga, merong vacuum that is being filled, that merong air, there is air that is being filled with further air. So kawawa talaga yung publiko, hindi maintindihan yan.
Yes, sir. Pero sir, noticeable, for example, in the case of itong supposed story by of U.S. President Trump signing an executive order for the release of Duterte by the ICC. I mean, anybody with any familiarity with the issues would know that that Trump would not have a. I mean, the U.S. is not even part of the Rome Statute, so that's quite a given. However, sir, the way that the story is written almost makes it look like it's a news story, like almost like it's a wire story, except that it is not by a wire agency. So apparently, people can't tell the difference anymore where to source their news. If it looks like news, it sounds like news. Maybe people think that it simply is news, whoever posts it or whoever publishes it.
Alam mo, Ed, ang test is whether it is sensible or not. Whether it was sensible for the President of the United States to issue an executive order, in favor of Duterte. These are the things. There was another story saying that the First Lady was, I think, arrested somewhere. It would have been in the papers if it were true. These are not sensible, ba? And I think the role of the media is to make people understand that on the face of these things, these are not sensible. And to stick to the facts. And what are the facts, Ed, that inform this case? One is that our own Supreme Court in 2021 ruled that our government was obliged to cooperate with the ICC. That was one.
Mm-hmm.
Two.
It's Cayetano versus Pangilinan versus
But
Cayetano.
now the lawyers are telling the court now, you were wrong. The Duterte lawyers are now telling that same court that it was wrong. It was mistaken. Now, the other one is that in the first appearance of Duterte at the ICC, the court itself said everything was in order. The arrest, the flight, and all circumstances surrounding that. That was clear enough. Oh, that's a fact. So if you alone took those two facts, you will be able to explain to yourself that these people in this country have no way of of uh, of enforcing any national jurisdiction over the case now that Duterte is in The Hague. It's simple, practical matter. You know, that cannot be done. Everything has been done for him that could be done, and nothing else could be done. Now, apparently, certain lawyers of Duterte would like certain people in this country punished instead of working for Duterte's, because they themselves know that there is no way they can bring back Duterte at this time. So they just want certain people punished. Probably the policemen, government lawyers, and people like them. But that's about it. But those are beside the point now. We're past that.
Yes, sir.
So
But
we
yes, sir.
should make people understand what applies and what does not.
Sir, to your point a while ago that we just stick to the facts, but isn't that also part of the problem that people nowadays don't seem to know anymore where to get their facts from? I mean, some people think that whatever they see on their social media feeds are automatically facts so long as they agree with them.
Well, I think news people should make them uh, should help them see what news or what utterances or what reports are sensible and what are not. And I think to a certain extent, like that can be done. If you told the people about the Supreme Court decision in 2021, I mean, that's easy enough to verify. And they all, I'm sure, many of them watched the night that Duterte was appeared in the International Criminal Court, and surely all of them, because that was the high-profile point of the of the uh, of the event, that the court declared that everything was in order, and therefore stop questioning the arrest, stop questioning the flight to The Hague, and stop questioning all the circumstances surrounding them. I think people could be made to understand that, because that's not very difficult to understand. What is Things become difficult precisely because we allow this bombardment of of uh, stupid contentions and fake news from all fronts. This is what. So I think there is a need for news people to um, shield the public from all these things by simply going to the relevant facts.
Okay, sir. What would you advise the public to keep in mind as far as this? Because this is only the start of what can be a very, very polarizing, 6 months to 1 year. What would you advise people to keep in mind when they see, look, hear, read about this issue?
Uh, I think they should. It is. I am not telling them not to listen to all these lawyers, but they should themselves realize that they've been listening to the same things. You know, and these things that the lawyers say should be juxtaposed with facts. And what are the facts? Supreme Court decision. And the latest one was that the Duterte lawyers were denied by the Supreme Court. And I think we should explain that it was predictable, because after all, before that, years before that, the Supreme Court had ruled that our government was obliged to to cooperate with the ICC. Of course, the question is that uh, uh, could the president have disobeyed the court? You know, the president did try to uh, somehow not cooperate. Actually, the president simply passively cooperated because it was a matter of politics. The president did not allow those investigators from ICC any look at official records. But then those investigators didn't need them. They already had them, and they came for first-hand testimonies. So that should be explained to our public. That, of course, Marcos didn't need to do that. But he had an out when he said that if the case was coursed to the Interpol, he would not be able to do anything. You know, that was his out. Indeed, no? He gave the impression that his hand was forced. Otherwise, he would be eroding his own relationship with the Interpol, an organization, international organization, important to us. Those are the things that should be explained, Ede. But I don't see or hear those things pointed out at all. I cannot quite understand why. When the idea is to make the public understand, to be more clear on what's happening here.
Okay, I'm afraid we're out of time, sir. But maraming salamat for joining us this morning and giving us your insights, veteran journalist Vergel Santos. Maraming salamat, sir.
Salamat.
And that's today's episode of Morning Matters. I'm Ed Lingao. We are One News, all sides, all the time.